Hi everyone, it's Liz here at Out the Breck. It's just me today. Ian's not here at the moment, so you've just got me. Now, you've probably noticed already that it's a little bit different today. I've decided to be in front of the camera. My reason for that is just in response to comments that we've had on other videos where people have asked us why we don't go in front of the camera, what we're trying to hide. Are we trying to hide something? So I just decided to get in front of the camera today just to quell any suspicions that anybody might have about us trying to hide ourselves and our faces from the public. And sometimes it's just nicer to see a face, to a voice. I've been on loads of other videos on this channel, so I'm clearly not hiding myself. And Ian, he's the cameraman usually, and he's behind the camera, which is why he's not often seen in front of it. So I hope that reassures those people that were wondering why we're not in front of the camera some of the time. Okay, before I start, in case you're wondering, this big lump under my jumper is a hot water bottle. I'm in one of our rooms in the house at the moment. It's actually quite chilly. So to keep warm during this video, I'm using a hot water bottle. Right, thank you for watching this video. The purpose of this video is to give our response to a judgment that was published on the 9th of October, a few days ago, in relation to the ongoing action at the Court of Session between us and EE Limited. Some of you may already know that that judgment has been published, and I don't know whether or not you've had a chance to read it, but we will pop a link of that judgment in a pinned comment to this video, so you can click onto that link and go to the judgment yourself to have a read through it if you choose to do so. Now, the judgment isn't a final judgment, but it is a judgment where the Lord Ordinary has made substantive decisions about the case that are highly detrimental to me and Ian, to us. Again, the reason I'm doing this video is to give our views on that judgment, and also to give a bit more information about the background to this case that's been going on now since October 2023. There's a lot of information that you probably won't be aware of, and you wouldn't be aware of it if we didn't do videos like this, and that's the reason for doing this video, because we've always maintained, and we continue to maintain, that it's really important that we are able to give our side of the story and publish our truth, because it's in the interests of the public. And we're really grateful to people that are following us on this channel and commenting and giving us support and giving us their views about what they think about what we're sharing about here at Out the Breck. So just do a quick recap for those of you that don't know much about the Court of Session case. This was an action that was brought against me and Ian by EE Limited in October 2023. The solicitors firm representing EE is Shepherd and Wedderburn, and they're one of the biggest law firms in Scotland. In 2023, EE got an interim interdict against me and Ian. For those of you who are not familiar with that term, it's basically the equivalent of a temporary injunction, and they got that granted by the Court of Session against me and Ian, restraining us from preventing EE from accessing land within titles owned by a forestry company that owns most of the estate here, called Caledonia Forest Land Investments Limited. And the order specified those titles as CTH 3449, CTH 5589 and CTH 3311. Those titles are registered in the Land Register of Scotland to the Forestry Company Caledonia Forest Land Investments Limited. A little bit of a tongue twister there. Now the dispute centres on the access to a private level crossing here at Out the Breck that EE need to use to reach the mast site. EE built a mast here on this land in July 2023, and in order to get to that mast they need to cross the private crossing at Out the Breck. Now, in terms of the facts of the case, I'm just going to summarise them. I'm not going to go on and on and on, but I'll just go through the facts. So in July 2023, EE Limited built a telecommunications mast here at Out the Breck on land owned by Caledonia Forest Land Investments Limited, specifically on Station Hill, which is located on the north side of the Far North Railway line. The Forestry Company granted permission to EE to build the mast on their land, and also granted permission to EE to access roads within land that they owned. In order to get to the mast, EE also need to travel along a road that's owned by Lord Thurso. So EE entered into an access agreement with Lord Thurso in exchange for payment to be able to use his road. If I look down, it's only because I'm looking at my notes, okay, I'm not being rude. So as I've said, to reach the mast, EE also need to cross the railway line using the private crossing at Out the Breck. EE claim in their action, in their pleadings that they lodged with the Court of Session, that Network Rail owns the crossing, and that Network Rail have given permission to the Forestry Company to use their crossing, and in turn EE have a right over the crossing under its contract with the Forestry Company. EE Limited alleged that me and Ian interfered with those contractual rights by preventing them from using the crossing to get to the mast site. And they claim that they had a right to use it, as I've said, because Network Rail own it. EE lodged a summons for calling in October 2024, which was about a year or just under a year of getting the interim order against us. A train's just going past, you probably heard it. Now, before I go in further into this video, I just want to make something really, really clear at the very beginning. It's EE Limited that brought the action against me and Ian. And it's EE Limited that brought the issue of the ownership of the crossing into this dispute, because it's EE as the pursuer claiming it has a right to use the crossing because Network Rail own it. Okay, so I just wanted to get that clear right from the beginning. It's EE that have brought the issue of the ownership of the crossing into this dispute, because they're alleging we've interfered with their contractual rights to use the crossing, because they have a right to use it because Network Rail own it. Okay, so it's about their claim, who owns it. I just want to tell you something that happened in February last year. So on the 29th of February last year, 2024, EE attempted to enforce the interim interdict through a sheriff officer here at Out the Breck. The sheriff officer attended on that day with contractors for EE and a locksmith. And he said that he was here or there to enforce the interdict for the workers to be able to use the crossing to access the mast site. I asked the sheriff officer to produce the order, and when he did, I went through the order with him and explained to him that it only applied to land owned by the forestry company, and I read out the title numbers, which I've already read out in this video to you. I explained that the order did not include the private crossing because that is not land that is owned by the forestry company. So it was quite black and white. Unfortunately, the sheriff officer wouldn't listen to us and attempted to enforce the order and got the locksmith at the scene to cut the locks off the gate. The locks were owned by me and Ian, so they caused willful vandalism to our property. They then attempted to enter the crossing. After some time, the sheriff officer realised that in fact he was unable to enforce the order on the basis of what I'd already told him, because the order did not include land that was not owned by the forestry company. So the sheriff officer at that point retreated and they all left. A few days later, we emailed EE's solicitor and we told them that we were open to resolving the dispute to avoid any further court action, and we just asked them to communicate with us so we could try and resolve it between us. EE's solicitor didn't bother replying to us. Following that, there was no communication from EE's solicitor to us for 8 months, so we were led to believe that the matter had just been dropped. Then, as most of you, if not all of you know, in September 2024, me and Ian brought an action against Network Rail at Wick Sheriff Court concerning the ownership of land here at Out the Breck, which included the private crossing. Then, only a few weeks after we brought the action against Network Rail at Wick Sheriff Court, EE's solicitor suddenly contacted us after 8 months and informed us that they were planning to lodge the summons for calling to start the action against us. Because of the timing, it was our opinion that this was clearly not a coincidence. We defended the action and we lodged our defences when the summon was lodged, and we claim in our defences that Network Rail do not own the crossing, and because Network Rail do not own the crossing, Caledonia Forest Land Investments Limited do not have a right to use it, and in turn EE don't have a right to use it. We claim that Ian owns the crossing, and that is a claim that we maintain. Network Rail do not own that crossing. Accordingly, EE needs our permission to use the crossing, and that was the basis of our defence. But again, bearing in mind that it was EE, the pursuer in the action, that first brought the issue of the ownership of the crossing into the dispute, and we were defending against that claim that EE was maintaining. Therefore, the onus was on EE. Obviously, EE were making the claim that Network Rail owned the crossing, then the onus was on EE to produce a valid ex facie, on the face of it, title in favour of Network Rail in support of their claim or their averment. Without a valid ex facie title in favour of Network Rail, EE's averment is irrelevant. And therefore EE would have no right to challenge Ian's claim to the crossing, having no competing valid ex facie title themselves or in favour of Network Rail. Now, initially the case was assigned to Lord Ordinary Braid. Lord Braid's a highly experienced commercial judge, and he dealt with the case from the beginning, and it was Lord Braid that granted EE Limited the interim interdict against us. After we lodged defences, a preliminary hearing was fixed for March last year, 2024. At that hearing, EE was represented by an advocate, and that advocate requested the court to give EE a 6-month cyst. Okay, cyst means, for anybody who doesn't know, a pause in the proceedings. It's effectively putting the case on hold for that period, and they were asking for 6 months. The advocate cited the reason was that because we had put in our defences about the ownership of the crossing, and that the dispute was between us and Network Rail, and that this dispute at the time was being heard at Wick Sheriff Court. EE's own advocate in this hearing acknowledged that Network Rail and not EE had the interest in the title position of the crossing, and it was for Network Rail to resolve it. Okay, that makes sense, doesn't it? Okay, EE weren't claiming to own the crossing, they were claiming Network Rail owned it, but at the same time EE knew that there was an ongoing land ownership dispute at another court between us and Network Rail, so clearly that was something that needed to be resolved. EE's advocate also told Lord Braid, this came from EE's advocate, not us, that it appeared from our pleas in law that we were raising a counterclaim against EE. And at that point, Lord Braid asked me and Ian if we wanted to lodge a counterclaim, and we looked at each other and we said yes, we would like to lodge a counterclaim. So Lord Braid allowed us to do that, and we subsequently lodged a counterclaim as well against Network Rail. In that hearing, Lord Braid refused EE's request to cyst the case for 6 months, and instead he suggested to EE's advocate that EE could resolve the matter by entering into an access agreement with us, which is what we were offering, and what we'd said in that hearing to Lord Braid is what we were willing to do. So EE could enter into an access agreement with us to use the crossing, and Lord Braid suggested that EE could take action against the forestry company for breach of warranty. This was a suggestion that came from the Lord Ordinary himself as a possible reasonable solution to the case. EE's advocate rejected both suggestions, which they were entitled to do, but they rejected Lord Braid's suggestion. Then, suddenly after the hearing with Lord Braid, the judge was changed, and Lord Braid was no longer presiding over the action. We had no idea that the judge had been changed until 2 days before the procedural hearing in the case, which was fixed for the 14th of May. And we were notified by a new clerk, who we hadn't had any dealings with, by email. Now, a procedural hearing is a significant stage in the proceedings, because this is where a judge decides on further procedure. And so we were unhappy, naturally, about the sudden change in the judge without any prior notice at such a critical stage in the process. We were concerned that the last-minute switch of judges would cause unfairness to us because of the lack of continuity. Because Lord Braid had full understanding of the facts of the case, and he'd been involved in the case since the beginning, since October 2023. So we were concerned that the change in judge would have an impact on the fairness of the process. And we were only left to wonder why the judge had been changed all of a sudden when Lord Braid had been on it from the beginning. Particularly since the last hearing, Lord Braid had seemed supportive of our position that the best way to resolve the dispute was for EE to enter into an access licence with us. But then he was removed. The case then came before another Lord Ordinary called Lord Lake, and his approach was totally different from that of Lord Braid's. Also, EE had changed their advocate. And in the procedural hearing that took place on the 14th of May, EE's position also changed. Like I said earlier, they previously acknowledged that the interest in the title position of the crossing needed to be resolved by Network Rail. And they'd asked for assist, which was refused, but that was their position. They were saying that this title position is not for us to resolve, it's for Network Rail. But now in the procedural hearing with a new judge and a new advocate, EE was now arguing that they wanted to proceed in a debate to argue that Ian doesn't own the crossing. So the issue of ownership was under scrutiny. At that time, the case was still ongoing at Wick Sheriff Court, so we argued to Lord Lake that it was inappropriate for a debate to take place to allow EE to challenge the relevancy of Ian's claim to the crossing when there was already a land ownership dispute about the crossing being heard at a separate court. Lord Lake allowed EE to proceed to a legal debate to argue that Ian did not own the land. And that debate was fixed for the 16th and 17th of July, and I'll go into that now. So this debate was over 2 days, and it was a debate that was called by EE the pursuer. In summary, EE argued that the 1979 deed that we were relying on, that granted the solemn to Station House, that included the solemn to the crossing, was not in Ian's name, and on that basis Ian couldn't rely on that deed. Now, during that debate, as party litigants, bearing in mind it was a legal debate, so there was a lot of complex legal arguments being discussed during that debate, with case authorities being discussed and referred to by the pursuer and by us. And it came to us during that debate of potential arguments that we wanted to include in our submissions. And so we asked Lord Lake to allow us a short continuation to seek some legal guidance because of the complexity of what was being discussed. We felt that we needed some legal guidance and to do some more research, and also to amend our submissions to include arguments about the relevancy of EE's claim that Network Rail owns the crossing. It was our view that that was a reasonable request. We weren't expecting a long continuation, but just enough time to allow us to do that. Lord Lake was reluctant and said that it would cause delays, and he wasn't happy to grant us a continuation because it would cause a delay in the process. So then we cited Rule 2.1 of the Court of Session rules to support our argument, and that rule gives the judge discretion to relieve a party from non-compliance with a rule if doing so is in the interests of justice. We argued that allowing us to update our submissions to effectively respond to EE's submissions in this debate was in the interest of justice, because we had a right to be able to present all relevant arguments in the debate as well. And that clearly arguments from both sides should be heard and received by the judge, you know, to be able to inform his overall decision on that debate. So we argued that it was clearly in the interest of justice for the Lord to allow us a short continuation to get some more legal guidance and to amend our submissions, and that this would require a continuation, and it would enable us to comply with fair notice, because EE would then get our new submissions and have time to go through them and respond. However, Lord Lake did not grant our request, and the debate was concluded without us, in our opinion, being given fair opportunity to present all our legal submissions about the relevancy of EE's pleadings as regards Network Rail's ownership of the crossing. We didn't get to present those arguments in that debate. Since July, we have repeatedly asked the court to allow us to have our own debate as the defenders, in order to get these legal submissions arguing the relevancy of EE's pleadings as regards their claim that Network Rail owned the crossing tested and heard before the court. But our requests have been repeatedly refused, principally on the grounds that it would cause a delay. However, it's our view that the desire to expedite a case should never come at the expense of procedural fairness. Yes, it's important to expedite cases and, you know, to promote the efficiency of the court, but the overriding duty of the court is to observe the rule of law and ensure procedural fairness. And it was our argument that it was procedurally fair to allow us to be able to have our own debate, because the issue of the relevancy of EE's averments in their pleadings needed to be tested, and the only way that could be done, because it was a preliminary issue, a relevancy issue, was in a debate forum. We just didn't understand the urgency. You know, you've got to ask yourself, what was the rush? why was the court so determined not to give us time to have our own debate? Why were they trying to avoid that from happening? That is a question that we would like you to ask yourselves. Now, just going to the judgment that was published on the 9th of October. In his judgment, Lord Lake says that we brought the issue of ownership of the crossing into the dispute, and therefore EE was entitled to argue the relevancy of that claim. And I quote Lord Lake from that judgment: "The defenders are the ones that have put their claim to ownership of the level crossing in issue by relying in it to defend their actions. The pursuer has responded to that, and in doing so has challenged the relevancy of the averments." Again, let's get something really clear. The issue of ownership was already in dispute between us and Network Rail in another court at the time EE lodged the summons for calling in the Court of Session. EE therefore already knew that the issue of ownership of the crossing was in dispute between us and Network Rail, but yet they started an action in the Court of Session against us, claiming Network Rail owned the crossing. It was EE that brought the issue of ownership into the dispute, because it was EE that brought the interdict against us, claiming it had a right to use the crossing because Network Rail owned it. We were therefore equally entitled to challenge the relevancy of EE's averments as to Network Rail's ownership, which is what we've been asking the court to allow us to do for months, to no avail. It's our view that instead what the court's done is place the onus onto us to prove ownership of the crossing by incorrectly suggesting that it was us that brought the issue of ownership into the dispute, when it wasn't. It was EE, the pursuer, clearly. In reality, it was EE that introduced this issue by claiming Network Rail owned the crossing and claiming that we interfered with their contractual rights because we stopped them from using the crossing. Therefore, the onus properly rests on EE as the pursuer to produce an ex facie title that's valid in favour of Network Rail before being able to challenge Ian's ownership claim to the crossing. By wrongly claiming that we as the defenders brought the issue of ownership into the dispute, the court effectively shifted the onus of proof onto us when it should properly rest with EE. What this did was allow EE to secure a debate on Ian's title claim when in fact it should not have been permitted to happen before the relevancy of the pursuer's pleadings had been tested. The onus was on the pursuer to produce an ex facie title in favour of Network Rail, and we claimed that they hadn't done that, and we wanted to test that relevancy of that claim in a debate, but the court wouldn't allow us to do it. Now, fast forward to October. At the beginning of October, we lodged another motion because we were not giving up on this subject, and we lodged another motion asking the court to assign us a diet of debate so that we could argue and make our legal submissions on the relevancy of EE's pleadings as regards their claim, their averments that Network Rail owns the crossing. EE opposed the motion, and an opposed motion hearing was fixed for Friday the 10th of October. Now, just so you know, EE claim that Network Rail owns the crossing by virtue, of an old deed from 1876. So just like us, we were referring back to a deed from 1979, EE were also seeking to rely on a very old deed from 1876. The deed in question is between Charles Robert Sinclair and the Sutherland and Caithness Railway Company. And this disposition was a feudal disposition that was registered in the General Register of Sassenes in 1876. EE claims that this 1876 deed disposed an area of land that included the crossing to Sutherland and Caithness Railway Company in 1876, and that Network Rail, as the successor to that railway company, now owns that land. There was a deed plan referred to in that deed, but no plan was produced by EE. So, in our motion, we lodged a note of argument in support of our motion for a debate, and our arguments were as follows. We argue that EE has not produced an ex facie title in favour of Network Rail. We argue that EE's claim that Network Rail owns the crossing is materially lacking in specification as to be irrelevant. Why are we arguing this? We're arguing this because there was no plan with the 1876 deed, only a verbal description in the body of the deed, claiming that 17 acres of land was disposed that was occupied by the Sutherland and Caithness Railway Company at that time, plus 18 inches outside the railway fences. Now, because there was no plan with that 1876 deed, you can only rely on the verbal description. Now, from that verbal description, it's clearly impossible for EE to prove that the land described in that verbal description corresponds to the same land that's in dispute and includes the crossing. It's just impossible. More specification is needed, i.e. EE need to show that they can show a title plan, and on that title plan be able to point out where the crossing is on that title plan, but they've not been able to do that. So, included in our note of argument with our motion, we requested that the court order EE to produce a title plan showing the extent of the land disposed to the Sutherland and Caithness Railway Company and mark on that plan where the crossing is located, and if they couldn't do that because no plan existed or was not available, they should be ordered to adjust their pleadings to that effect. In EE's debate back in July, they argued that because Ian wasn't party to the 1979 deed, he couldn't rely on that deed. But we also argue that Network Rail wasn't party to the 1876 deed. It was Sutherland and Caithness Railway Company that's now dissolved and was a Scottish company. So our argument is exactly the same. So why can't we argue that, but EE can? Another important fact is that it's impossible for Network Rail to own the crossing by virtue of the 1876 deed, because the private crossing didn't exist in 1876. According to records, it wasn't built until around 2006. around 130 years after the 1876 deed. So how could the crossing be included in the land that was dispossessed in 1876 to the Sutherland and Railway, the Sutherland and Caithness Railway Company? It was impossible for it to be included because it didn't exist. Another argument that we had was that the crossing was actually built in around 2006, not by Network Rail that owned them, that ran the rail infrastructure at that time. It was built by the forestry company that owned the land at that time. And that information clearly supports our position that the Solemn to the crossing is not owned by Network Rail, but it's owned by us as the new owners of Station House, because the forestry company at that time in 2006 who built the crossing owned the Station House subjects. So in our arguments, we argued that EE had not produced a valid ex facie title in favour of Network Rail, making this a relevancy issue suitable for debate that we should be allowed to have before the judge, the Lord Ordinary, makes a judgment on the pursuer's debate. Because clearly our arguments would have a direct bearing on the overall decision by the judge. We also argued in the note of argument that EE's averments regarding Network Rail's ownership, if they were found to be irrelevant and excluded from proof, then all of EE's related averments claiming a right to use the crossing by virtue of Network Rail's ownership and asserting that Ian does not own it must also be considered irrelevant and excluded from proof. EE cannot legitimately challenge Ian's claim to the land without having a valid competing prima facie title in favour of Network Rail in the first place. It's our opinion that these were obviously very strong legal arguments in favour of us having a debate on the relevancy of EE's pleadings and before the court issued its judgment on the pursuer's EE's debate. Because our arguments clearly had a potential of a significant bearing on the court's overall decision. So what happened was on the 8th of November, we lodged these arguments, our note of argument, with the court on the 8th of October, 2 days before the fixed motion hearing on the 10th of October, which is usually what you would do. No sooner as we'd lodged our arguments, those strong arguments in favour of allowing us to have a debate, we got a letter back from the court the very same day informing us that Lord Lake was planning to publish his judgment the following day, on the 9th of October. And this was while there was a motion pending, a live motion pending for us asking for a debate. And yet we were being told that the Lord Ordinary was planning to publish his judgment before this motion had even been heard. We were astounded. So the consequence of that is that the publication of the Lord Ordinary's judgment effectively rendered the purpose of our motion hearing pointless. because he'd already made a decision. This was very concerning to us, and we have concerns about the procedural fairness of this to have been allowed to have happened. The question must be asked is, why was the court so determined not to allow us to have a debate on the relevancy of EE's averments as to Network Rail's ownership of the crossing? And why was there such urgency in issuing the judgment when we had a live motion pending that was to be heard just the following day? Why could that judgment not have been put on hold until the motion hearing had happened, or until we'd had a debate on these preliminary relevancy issues? That's the question that we're asking ourselves. So this is where we're at now. It's our intention to appeal the Lord Ordinary's judgment by lodging a reclaiming motion, because we are concerned about the propriety of what's happened, and it's our view that we've not been given a fair opportunity to present all of our legal submissions before that decision was made by the judge to exclude the majority of our defences and to dismiss our counterclaim. It rendered the motion hearing pointless. So we notified the court and EE via their solicitor of our intention to appeal this judgment on the same day the judgment was published. We also lodged 2 minutes in process formalising our position that the judgment that was published on the 9th of October, when a live motion hearing was pending the next day on the 10th, had effectively rendered the motion hearing pointless, and there was no point in going ahead with it. And because we were planning to appeal the judgment, we instead asked the court to continue the motion hearing pending the outcome of our appeal application, which to us made sense. So contrary to what people have been saying, that we just failed to attend the motion hearing on Friday on the 10th, that's not true. We corresponded with the court at length the day before and lodged formal documents in process asking the court to continue the motion hearing because we planned to lodge an appeal, and it wasn't appropriate in the circumstances for that motion hearing to go ahead because A, it was pointless, and B, because we were lodging an appeal against that same Lord Ordinary's judgment, we weren't comfortable going before him again until the outcome of the appeal application. We weren't surprised to discover that the motion hearing went ahead in our absence, and our request for a continuation pending the outcome of our appeal application was refused, and the motion that we'd lodged was dismissed by the Lord, claiming that it was for want of insistence, when clearly that's not true, because we did insist on that motion. We insisted and requested that it be continued until the appeal hearing or the appeal application had been heard, because the whole point of the appeal of the judgment is because we weren't given fair opportunity to have our motion heard before the judge issued his judgment. Okay everyone, I know it's been a long video, so I do apologise, but there was a lot of information I really wanted to share with you, and if there's any questions, please ask. And yeah, again, I know it was a long video, but these things sometimes just can't be explained quickly. We have to go through things just to make sure you've got all the information. So that's where we're at the moment. It's our intention to appeal the Lord Ordinary's judgment that was published on the 9th of October. We maintain that Network Rail do not own the private level crossing at Alton-le-Brec. We own it, and we will continue in this action for the truth to prevail. Thanks very much for watching. Bye bye.